But I'm not hearing her.
Can I have
meeting is in.
Leave meeting, no.
Can I have your appearance, please?
Cut it.
We are not hearing her.
Learned Council, is there any of the council hearing?
She's talking.
She's talking.
I can hear you. I can hear you, my lord.
Yes, go ahead and announce your appearance.
Okay. I am, may it please this honorable court?
Yes.
I am Olayemi Afolayan, and my appearance is for the defendant.
Very well.
But I heard that before.
Any other appearance? Is there any appearance for the claimant? Is there any appearance for the claimant?
Is there any appearance for claimant?
My lord, I saw claimant at the background just now, but it's only the lawyer I can see now.
And let the lawyer announce his appearance. God Wobi, are you for the claimant?
But it's a good day. I will go. Appear your appearance. Announce your appearances, please.
Remove that thing from your ears. Remove that thing from your
the
ears.
earpiece. Remove it.
Remove the
Remove your
earpiece
earpiece.
and use.
Remove it.
Go ahead and announce your appearance. God Day, is it God Day Owobi Owobu?
God Day Owobu is.
Are you counsel for the claimant? Very well, I've noted your name as counsel for the claimant.
Yes, my lord.
Here's the judgment of the court. Can you hear me now?
Yes, my lord.
Yes, my lord.
Very well. So this is the judgment of the court. It is the claimant's case that he was an employee of the defendant, and upon an allegation of criminal conspiracy, which led to his trial before an area court, consequent upon which he was suspended, and during which period he was not paid half salary even after he pleaded that he be paid half salary, and which plea the defendant responded that it could only be paid after he has been discharged and acquitted by the court. Please, court registrar, mute your system.
Okay, ma'am.
He was subsequently discharged by the court, and pursuant to which he was recalled back to his duty. However, after his recall, he was subjected to an administrative proceedings despite his discharge and acquittal by a court of competent jurisdiction. He was also made to sign an undertaking under duress, waiving his salaries for the period of the suspension as a condition for his recall. He has made demands for the payment of his arrears of salaries, but the defendant refused to pay, and his monthly salary during the said period is in the sum of 89,528 naira 64 kobo. And that the total, it was owed 63 months, beginning from May 2008 to August 2013, and which sum has accumulated to the sum of 5,640,304 naira 32 kobo. It is against this backdrop that claimant filed a general form of complaint. That he filed a general form of complaint in this court on the 7th of March 2022, wherein he sought the following reliefs against the defendant. A declaration that the claimant, being a civil servant, was entitled to have salary while on suspension. B, a declaration that the claimant is entitled to the other half salary after he was discharged and acquitted by competent court of jurisdiction of the criminal allegation upon which the claimant was suspended. 3, a declaration that the claimant, having not been paid any salary for the period he was suspended, is entitled to his full salary arrears for the third period after he was discharged and acquitted of the criminal allegation upon which the claimant was suspended by a competent court of jurisdiction. 4, a declaration that the administrative proceedings are tried the claimant for criminal allegation after court of competent jurisdiction discharged and acquitted the claimant of the same criminal allegation is illegal, null, and void. 5, a declaration that the purported letter of undertaking signed under duress by the claimant forfeiting his salary arrears for the third period, which emanated from the administrative proceeding after the claimant was discharged and acquitted by court of competent jurisdiction, is void and of no effect. 6, an order of the court directing the defendant to pay the claimant the sum of 5.6 million naira, being the claimant's arrears of salaries for the period he was on suspension. 7, general damages of 10 million naira for the psychological trauma suffered as a result of non-payment of the claimant's salary arrears till date. And 8, exemplary damages put at 5 million naira only. The defendant, in response to the claimant's action, filed its statement of defense, wherein it averred that the claimant, after he committed a misconduct in 2008, was suspended and tried by the court. Upon being recalled, he wrote a letter of commitment not to do such again, and which also contained an undertaking to waive his alleged arrears. However, in 2016, he was reported to have been involved in yet another misconduct, which eventually led to his dismissal. In specific response to the claimant's averments, the defendant averred that claimant committed the misconduct of forgery and stealing, which gave rise to a complaint to the police and his suspension from office, and pursuant to which claimant and others were charged for criminal conspiracy, dishonest or fraudulent execution of deed of transfer. Claimant had initially requested for payment of her salary during the period of suspension, which request was turned down on the ground that he was not entitled to same. Upon his discharge and acquittal on the criminal charge, he was recalled to work, but an administrative proceeding for the hearing of acts of misconduct against claimant had commenced before his trial in court, and despite the discharge and acquittal, the defendant was duty bound to make a finding on the complaint of misconduct against claimant. Claimant was not made to sign the undertaking forfeiting his salary under duress, as he did it on his own volition. The defendant finally averred that claimant is not entitled to the relief sought. The defendant equally filed a notice of preliminary objection challenging the jurisdiction of this court on the following grounds. 1, that Section 22A of the Public Officers Protection Act mandates any person who intends to commence any proceedings against any public officer or any act done in pursuance of execution or intended neglect or default in the execution of any such act, law, duty, or authority to bring such action within 3 months next after the ceasing of the default or neglect thereof. 2, the claimant respondent suit is an action for recovery of an alleged salary arrears owed the claimant respondent by the defendant applicant, a public officer within the contemplation of the Public Officers Protection Act. 3, that this honorable court lacks the requisite jurisdiction to hear and determine the suit as same is filed outside the mandatory period of the 3 months. And in the alternative, 4, that this suit does not disclose any cause of action against the defendant, as the claimant has by his conduct and words waived any alleged right he may have to request for the payment of the arrears of salaries which allegedly accrued during his suspension for misconduct. And finally, that this honorable court lacks the requisite jurisdiction to hear and determine the suit, as in the absence of reasonable cause of action, same is incompetent. Filed together with it is a 5-paragraph affidavit and written address in support. Claimant also filed a counter affidavit in reaction to the notice of preliminary objection and equally filed written address. The defendant in response filed a further affidavit and also a reply on point of law. I've captured all that in the judgment. On the 27th of June 2022, claimant opened his case by testifying for himself as he adopted his written statement on oath as his oral evidence. He tendered documents admitted and marked as Exhibit S to S7. He was subsequently cross-examined by the defense counsel. The defendant equally opened its defense by calling one Yusuf Hassan as DW. He equally testified on behalf of the defendant and tendered documents admitted on record and marked as Exhibit H and H to H3. He was equally cross-examined by the claimant counsel. At the close of trial, parties filed their respective final addresses, which I have equally captured in the body of this judgment. So I will skip that and go straight to the decision of the court. I've given an in-depth consideration to the case at hand with particular attention to the originating processes, the preliminary objection filed, the final written addresses, and the list of additional authorities filed by the defendant. In view of the perusal of the above processes, I am of the firm view that the issues that will best determine this case are: 1, whether there are factors robbing the court of the necessary vials or jurisdiction to entertain the case. And if this is answered in the affirmative, whether the claimant is entitled to the relief sought. There is no doubt that the issues raised by learned counsel above touches on the jurisdiction of this court, and which this court must first, one way or the other, resolve before it moves on to consider the merits of the case. Jurisdiction, as the law is tried, is the lifeblood and bedrock of all trials, without which the trial will amount to a nullity. It is the lifeblood on which all trials thrive. See these cases: NDLEA and others versus Wala, citation captured; the case of AG Gombe State and another, and Abdul Gafaru Yusuf and Company Nigeria Limited, citation also captured; and the case of Odom and PDP, citation provided. It is the law of commonplace that an action filed after the prescribed period is statute barred, as was held by the Apex Court in the case of Amadi and another, and INEC, citation captured. The essence of a limitation law is that the legal right to enforce an action is not a right in perpetuity, but a right generally limited by statute. The overriding purpose of limitation laws is expressed in the Latin maxim, interest re publicae ut sit finis litium, which is to the effect that litigation shall be automatically stifled after a fixed length of time, irrespective of the merits. As such, a party must bring its action within the statutory period. See the case of Abubakar and Michelin Motor Tire Services Limited, citation captured. Courts have held that laws like limitation laws, which takes away citizens' right to access the court, must be construed strictly. The case of Nigeria Army and Yakubu, citation captured, and the case of Nwosu and Imo State Environmental Sanitation Authority, citation also provided. Generally, in order for a court to determine whether an action is statute barred, the court will examine the statement of claim filed by a party, which invariably discusses when the cause of action arose, and situate it with the writ when the writ of summons, or in this case, the general form of complaint, was filed in court, and thereafter compare both to see if the action is not yet statute barred. See these cases: Duzu and Yunusu, citation captured; Hassan and Aliyu, citation provided. Court registrar, please mute your phone. Mute your phone, mute your phone. However, the Apex Court, in the light of its recent decisions, have shown—
Mute your phone. I know you mute your phone.
Court Registrar, I hope you have muted your phone because it's making noise. However, the Apex Court, in the light of its recent decisions, have shown that the above rule is one that admits an exception. In the case of Karushi and Gwagwa citation captured, the court held that generally, to determine if an action is statute bad, it is the originating process that the court should look at to find out that the date, the cause of action accrued, but where an objection that the suit is statute bad is considered and determined after the conclusion of evidence, as in the instant, all processes and evidence before the court must be considered, especially where the objection is determined as part of or along with the final judgment on merit of the dispute in the case, like is done in this instant. And further, at page 162, paragraphs A to D, to hold that the general rule that it is the originating process that should be considered limits the court from considering the processes filed by the defendant in response to the originating process, even when objection was determined by trial court after the conclusion of evidence. The court was of the view that in such cases, courts ignore other evidence in the case that disclose the actual cause of action and pretend that it does not exist, and such approach violates the fundamental principle of fair hearing that requires the court to consider all evidence on a point in determining that point. The court held that since the preliminary objection was determined along with the originating summons, the trial court was bound to look at all the processes before it for consideration. See also the case of Abdullahi and Loco and others citation captured, the case of Wali and APC citation captured, and the case of APC and Larry citation provided. The above position of the law, as expressed in the case of Kaushi and Gwagwa Supra, was equally reiterated by the Supreme Court in one of its recent decisions delivered on the 1st of February 2023, in the case of Husseini and Atta citation captured, wherein the court held that as a general rule in determining whether an action is statute bad, it is the writ of summons and statement of claim that should be considered, or in an action commenced by originating summons, the originating summons and the affidavit in support that are considered, where, however, the objection as to limitation of time is considered by court after evidence has been taken by the court, or where the suit is commenced by originating summons procedure, and the affidavit of the parties, as well as the objection are adopted together at the same hearing, the court will be entitled to consider all the materials before it, including the statement of defense or counter affidavit of the defendant. The court went further that this approach accords more with the principle of fair hearing, as the defendant who has adduced evidence is entitled to have his evidence considered by the court in determining the objection to the limitation of action. The effect of the above current position of the law is that the general rule that it is only the statement of claim, which is herein as a statement of fact that is relevant to be considered in determining whether an action is statute bad, is inflexible and not without its own exception. Please let me pause here and tell the court registrar, please mute your systems. Mute your phone, or if you are using a tablet, mute it, because you are disturbing me. Adams, Bridget, mute your system.
Yes, my lord.
Mute it. I don't want to hear your voice. I don't want to hear any noise on the ground. Thus, the approach in recent times, especially where the merit of the suit is considered together with the preliminary objection, alleging limitation of action, and which current position is that in such situations, the court is to consider every material fact and evidence placed before it. In the instant suit, the preliminary objection on limitation of action based on POPA is considered by this court together with the main suit in the judgment as ordered by the court on the 26th of May, 2022. It is only expedient at this stage that all the processes before the court, including evidence, will be considered in determining whether this action is statute barred. It is in the light of the above that I will consider all the processes and evidence in this case in the determination of whether claimant's action is statute barred or not. First, there is no doubt that the defendant is a public officer and the act complaint of giving rise to this action is a public duty. See the case of Ofoboshe and Lokoja local government citation captured and the notarial case of Ibrahim and JSC Kaduna State Supra. It is also tried that any action which is instituted against the act of any public officer while performing his public function, which is instituted outside a 3 months period envisaged by the Public Officers Protection Law, is statute barred. The rule in section 2(2)(a) of POPA is, however, not absolute and not without its own exception, like most rules. Claimant in this case is claiming for arrears of his withheld and unpaid salaries while he was on suspension. The defendant on his own part, be it its preliminary objection and the statement of defense alleged that claimant had written to IDS requesting same in 2011, and he was told by a letter dated 31st of October 2011 that he was not entitled to it, and that his cause of action started to run from that date. I've gone through the pleadings of parties and the evidence on record, and I disagree with learned counsel for the defendant that claimant's cause of action arose since 2011. Parties in this case are both relying on the provisions of Rule 030406 of the Public Service Rule, which is also known as PSR, on suspension. In fact, Exhibit H shows that there has been a series of communication between claimant and the defendant. In the said letter, reference was made to the provision of the PSR, which is Rule 030406, which states that an officer suspended shall be suspended from the employment of his or her emoluments. It is clear from the contents of a letter dated 31st of October 2011, which was written to claimant in 2011, that the suspension of claimant and denial of his emolument was pending the determination of his trial before the court. In fact, in the letter, it was stated that claimant could raise a plea for his salaries after he has been acquitted. The claimant in the instant suit, after the said letter of October 2011, was later discharged and acquitted by the court and subsequently recalled back to work by the defendant. Claimant's cause of action for the recovery of salaries during his suspension arose when he was recalled after his acquittal, and he was not paid his salaries which were suspended. In my firm view, claimant's cause of action on his arrears of salaries during the period of suspension arose in the year 2013, when he was recalled back to work on the basis of his acquittal and was not paid his salaries that were suspended pending the determination of a case against him. Assuming the court is even wrong on the date of the accrual of his cause of action, and that the cause of action accrued in 2011 and not 2013 as stated by this court, while claimant filed this action in 2022, it is in my humble view that this fact alone doesn't mean that claimant's right of action has been taken away in view of the facts and circumstances of this case. I will now proceed to address why I took this view. Admittedly, the PSR, by its Rule 030406, imposes a term on suspension that an officer on suspension shall equally be suspended from the enjoyment of his emolument, even though it was not specifically stated in the letter of suspension to be so. Learned counsel for the claimant in his final written address submitted that though the rule provides that suspension shall be without pay, since the letter of suspension did not specifically say so, claimant ought to be paid while he was on suspension by the defendant. In addressing this issue, I will place reliance specifically on the decision of the Court of Appeal in the case of Globe Motors Holdings Nigeria Limited and Oyewole, citation captured, where the court per Sierra Joe JCA held those, and I quote, "Since suspension is not a termination of employment contract, nor a dismissal of the employee, the implication is that the employee is still in continuous employment of the employer until his recalled or formally terminated or dismissed, pending his recall or dismissal or suspension, pardon me, please, pending his recall or dismissal, a suspended employee is entitled to his wages or salary during the period of suspension, unless the terms of a contract of employment or the letter of suspension itself is specific that a suspended employee will not be paid salaries during the period of suspension," unquote. It is clear from the above that an employee will only be denied a salary while on suspension if the terms and condition of employment or the letter of suspension imposes a term of no pay on the suspension. In the instant case, the letter of suspension did not impose any term on the suspension. However, parties agree that it was the PSR that governed their relationship. Then it means that the parties ought to be bound by the provision of the PSR. The PSR clearly stated by its Rule 0304 policies, as I've stated earlier, the suspension also includes suspension of emoluments. Therefore, even where it was not stated that claimant suspension is without pay, the PSR has already imposed a term of suspension of salaries on its suspension. It is worthy of note. The parties in this case, through their affidavit in support and in opposition of a notice of preliminary objection, have made the issue of whether claimant voluntarily forfeited his salary as a condition for recall an issue in dispute. According to claimant, vid. Paragraphs 8 and 9 of his counter affidavit in opposition to the notice of preliminary objection after the conclusion of the administrative proceeding, which was initiated upon his recall, he was instructed to write a letter of commitment, and the defendant made it a condition for him to resume duty, which move he initially refused, but had to comply due to the sufferings of his family. These positive assertions of claimant were not met horizontally in the further affidavit filed by the defendant in response to claimant's counter affidavit. Paragraph 4K of the said further affidavit merely states that paragraphs 8 and 9 of the counter affidavit are untrue. The true position of the law is that a denial in an affidavit must be precise, concise, and exact, and it must not give room for conjecture or speculation. Otherwise, it is in law and fact not a denial. See these cases, Tilly Jado and Company Nigeria Limited and Access Bank and Order, citation captured. The case of Chairman, Economic and Financial Crimes Commission and Little Child, citation also captured. The courts have also held that where in a counter affidavit, a respondent makes some feeble and shallow averment in denial of specific facts in an affidavit, such averments are mere general denials which are ineffective as a challenge to serious averments made against him. See the case of Kanyip Industries Limited and Ekong, citation captured. The case of App and Others versus Oturi, citation equally captured. Claimant made specific averments of facts in paragraphs 8 and 9 of his counter affidavit as to the fact that he was instructed to write the letter of commitment by the defendant. The response of the defendant by paragraph 4K of the further affidavit in response to the specific averment of claimant is a feeble denial, which is no denial at all. Again, the defendant who will want the court to believe by paragraph 4K that claimant's conclusion of administrative proceeding was not instructed to write the said letter of commitment to waive his salary has failed to bring before this court the record or document showing that the conclusion of administrative proceeding, showing what the conclusion of the administrative proceeding was. By the provision of section 167D of the Evidence Act 2011, the court may presume that evidence which could be produced and is not produced will, if produced, be unfavorable to the person who withholds it. See the case of PDP and Alechenu and other citation captured. The purport of this provision is that where a party to a suit does not adduce evidence which is supposed to and has the opportunity to adduce, then it may be presumed that the evidence will be against him if produced. The defendant who has not specifically and horizontally met claimant's position above by a positive denial also failed to annex to its further affidavit in opposition to the counter affidavit the documentary evidence showing the conclusion of the administrative proceedings. This court presumes that the defendant failed to produce a record of the conclusion of the administrative proceedings because it knows if it did, it will be unfavorable to its case. Also, the claimant viewed its pleadings specifically in paragraph 10 of his statement of fact and his evidence in paragraph 11 of his written statement on oath made the voluntariness of the said letter of commitment wherein he forfeited his arrears of salaries an issue. This is a material issue on which the defendant ought to cross-examine claimant on. The defendant, by paragraph 13 of his statement of defense, averred that claimant was under no duress at all to sign his letter dated 6 November 2013, or any document on the basis that same was a condition before he is allowed to resume at his duty post. The defendant also, by paragraphs 14 and 15 of his statement of defense, stated that the condition that claimant should forfeit his salary did not arise because he had already been and that he on his own volition expressed his decision not to request for salary arrears. Learned Defense Counsel on 27th of June 2022, while cross-examining claimant, never deemed it necessary to cross-examine claimant on the issue raised in his pleadings and evidence that the letter of commitment wherein he forfeited his salaries was not voluntarily made. Put differently, the defendant did not challenge or contradict the testimony of claimant as to the voluntariness or otherwise of the said letter of commitment in cross-examination. No question was put to the claimant concerning his testimony that it was made to make the commitment under duress. It is the law of commonplace that where a witness is not cross-examined on a crucial and material point, the only conclusion is that the adverse party who ought to have cross-examined the witness accept the evidence of the witness as true. See these cases: Oluwole and Olatuji citation captured, First Bank and Momo citation provided, Adrawus and another versus Maksha citation captured, the case of Ohimogbo and ED citation provided, and the case of Gaji and Paye citation also provided. The evidence of the claimant that the letter of commitment is not voluntarily is therefore taken as admitted. It is worthy of note that DW, while under cross-examination by learned claimant counsel, admitted in evidence that claimant was on suspension between the 14th of May 2008 to the 1st of September 2013, and he was not paid his salary arrears after he was discharged and acquitted by the court. In fact, DW stated under cross-examination that it was not claimant's right to be paid his arrears of salary after he has been discharged by the court. How convenient. In the instance suit, claimant was supposedly recalled to work by Exhibit S4 in September 2013. However, Exhibit S5, which is the letter of the administrative proceedings dated 13th of September 2013, written after the initial letter of recall, shows that claimant recall in Exhibit S4 was only a sham, as Exhibit S5 stated in its paragraph 3, that claimant will not be allowed to resume his official duties until administrative proceeding is concluded. It was after Exhibit S5 that claimant wrote the letter of commitment on the 6th of November, where he promised to forfeit his arrears of salaries if he's allowed to resume his work. And it was obviously after this that claimant was allowed to resume work. In fact, DW admitted under cross-examination that after claimant administrative recall, he was again asked to stop work, and an administrative proceeding was again instituted against him after his discharge and acquittal by the court. And it was After the said administrative proceeding, that he wrote his letter of commitment where he forfeited his salary. In view of the evidence of DW under cross-examination and the evidence in this case, I believe claimant's assertion that he was induced to forfeit the said salaries as a condition to be recalled to work, because why was there a need for an administrative proceeding for the same offense the court has acquitted him after his purported recall? Why was it after the said administrative proceeding that claimant had to write the letter of commitment pleading to be allowed to start work when the court has already cleared him? Why was it after the said letter of commitment that claimant was really and actually allowed to resume his duty properly, because it is in evidence that claimant worked for the defendant afterwards and was only dismissed 3 years later? Since the suspension of claimant was pending the determination of a charge against him, and which suspension the PSR has already imposed the term of non-payment on, when the claimant was recalled upon being found innocent by the court, the salary should have been restored immediately, because then it was like he did not commit misconduct and should not have been suspended. Claimant need not beg to be allowed to resume his work via the letter of commitment that is Exhibit H2, wherein he also undertook to forfeit his arrears of salaries if allowed to resume work. All this lend credence to the fact that claimant was induced to waive or forfeit those salaries before he can be allowed to continue his work, because what is the need for the request in the first place? The fact that claimant was even made to make such request in Exhibit S6, forfeiting his salaries months after he has been discharged and acquitted by the court and recalled to work, is appalling. Claimant ought to have been paid immediately he was recalled based on his acquittal in September 2013. The fact that he still had to write a letter months after in November 2013, pleading that he be allowed to continue his work and that he would, as a condition for such, forfeit his salary during period of suspension, smacks of being pushed to the wall. It is obvious claimant was left with no other option. Ordinarily, from the moment claimants were recalled, he should have been paid his salaries for the period of suspension. This view of mine finds credence in the recent decision of the Court of Appeal in the case of City Central Group of Companies Limited and AZ, citation captured, wherein the court held us, and I quote, "Generally, there are two types of suspension: suspension pending inquiry and suspension as a punishment. The former is not a punishment per se, for if the employee is not found guilty, the suspension will be lifted and he will be netted to receive full wages for the period as if he was never suspended. On the other hand, suspension imposed on the establishment of guilt is in the nature of punishment. It can have adverse impact on the career prospect of the employee within the organization. The point to underscore, however, is that suspension, whether pending inquiry or as a punishment, is not termination or dismissal. The contract of service remains subsisting and unbroken until it is lawfully brought to an end by either party, unquote. Claimant's suspension in this instance was one made pending the determination of a charge against him, and not one of punishment, and as such, the moment he was discharged and acquitted, he ought to be paid his entitlements. Claimant was ordinarily supposed to be paid his salaries for the period he was suspended immediately he was recalled by the defendant in September 2013. But the defendant chose not to pay him and instead continued an administrative proceeding which was itself not needed, and claimant was made to now write Exhibit H2 in November 2013, 2 months after he has been recalled. The defendant are now hinging the failure to pay on Exhibit H2, which was written 2 months after claimant had been recalled. If the defendant had any intention to pay claimant the said salaries, he would have paid him in September when he was recalled, as I've stated earlier, and not wait for claimant to write to waive the said salaries 2 months after his recall in November. All this point to the fact that the defendant never intended to pay claimant the said salaries in the first place, which was why it forced claimants to make Exhibit H2, so that it could hide under that. This is crude and an abuse of office and wickedness on the part of the defendant. The withholding of claimant salaries for the period he was on suspension after he has been acquitted by the court and recalled to work under the guise that it undertook to forfeit same is an illegality in itself, making him write Exhibit H2 before he was properly so recalled and allowed to continue his work is a show of abuse of office on the part of the defendant, as I've stated supra. See the case of Olowo Nihi, an EFCC citation captured, where the Court of Appeal, in considering a similar case, where an employee was asked to waive his salaries during the suspension after he has been vindicated, as a condition for his recall, held us per NIMPA JCA, I quote, the cross-appellant was still in service, and the said salaries he was asked to waive is the same salary he should have earned, but for the illegality of the chairman of the cross-respondent. Acceding to the findings of a trial judge, which is a principle for termination or dismissal cases, is applicable here. If the argument of a cross-respondent is that the suspension of salaries was pending disciplinary case, when the cross-appellant was recalled upon being found innocent, the salary should have been restored because then it was like he was not suspended at all. Why should there be a gap in the service of a cross-appellant when he did not commit any offense or was found guilty of misconduct? In the termination of employment, the founding document is letter of employment, which was not the basis here. So the need to start with the terms of engagement did not arise. How can you suspend a person for 2 years without pay and then recall him on the condition that he must waive the salary for the 2 years? If the cross-respondent did not believe he was entitled to the salaries, why did they ask him to waive the salary? The cross-respondent knew that the salary should be paid, thus the Banana Republic games it played. After all, the letter of suspension, that is Exhibit CW1 to S, did not state any terms of the suspension to include denial of salary. Furthermore, public service rules stipulate that disciplinary cases should be resolved within 60 days. 0030307. The cross-respondent in this case took more than 2 years to recall the cross-appellant. Very tragic, and said it is happening with our modest advancement in human rights and due process to allow the finding of the trial court to stamp illegality and injustice, unquote. Taking a cue from Olowo Nihi's case supra, I find that the defendant in this case had acted outside the law and without legal justification by failing to pay claimant his arrears of salaries after his discharge and acquittal by the court, and also by forcing claimant to make the letter of commitment wherein he purportedly waived his salaries during the period of suspension, and thus cannot be seeking protection under Section 2 of POPA. In the case of Azan and Aliyu citation captured, the Apex Court per Onoge JSC stated thus, and I quote, it is however correct that when a public officer acts outside the scope of his authority or without a semblance of legal justification, he cannot claim the protection of the provisions of the Public Officers Protection Act, unquote. Adeke GSC, now retired, on his own part at page 621, emphatically puts it thus, and I quote, a public officer can be sued outside the limitation period of 3 months if at all times material to the commission of the act complained of, he was acting outside the color or scope of his office or outside his statutory or constitutional duty, unquote. See also these cases, Adamawa State Government and another, and Umaru and other citation captured. The case of Ayodele and another, the case of PSC and Ayodele and another citation provided. Podo and Gombe State Government and other citation captured. I am of the view, therefore, that Section 2 of POPA will not apply in this instant. Also, in my view, this case falls within the exception under continuance of damage and injury and claims for labor and work done or recovery of debt. The arrears of salary which claimant is ordinarily entitled to after he was being discharged and acquitted by the court and subsequently recalled to work still remain unpaid till date. In the case of Federal College of Education Technical, Guzau, and Abdullah Muhammad Guzau and another citation captured, the Court of Appeal per Oho JCA held us, and I quote, it is important to note The respondent claims that the court below in many respects constituted exceptions to the applicability of Section 2 of Public Officers Protection Act. Quite contrary to the contentions of the appellant in this case, the respondent were clearly able to establish at the court below that theirs was a typical case of outright deprivation of their entitlements, salaries, pension, and gratuity by the appellant, whereas their employment were only terminated and were not dismissed. Therefore, we tell their entitlement, salaries, pension, and gratuity without cause is bound to amount to an act of continuance of damage or injury, which is an exception to the provision of Section 2 of Public Officers Protection Act. Arising from the foregoing, this court therefore finds and holds that the provisions of Section 2 of Public Officers Protection Act do not apply in the circumstance of the instant case being a claim, the bedrock of which is grounded in labor and work done, unquote. Since claimant's salary was suspended pending the determination of a charge against him the moment he was acquitted by the court, it is as if there was no gap or break in his service and is entitled to his salaries for the period of suspension. See also the case of Olowoni and EFCC. His claims for his arrears of salaries, his claims for labor and work done, and the fact that the salaries still remain unpaid today makes it one of continuing damages, which is an exception to Section 2A of POPA. The other leg of claimant cases as regards the administrative proceeding that was instituted against him after his recall to work for the same offense for which he was acquitted by the court. The defendant, in response to the claimant's assertion, averred in paragraph 12 of his statement of defense that the administrative proceeding for the hearing of acts of misconduct against him had commenced before the claimant was charged to court, and despite his discharge and acquittal by the court, the defendant was duty-bound to make a finding on the complaint of misconduct made against claimant. It is clear from the above averment of the defendant that the administrative proceeding was in respect of the same act, which claimant has been cleared by the court, and that the proceeding was done in spite of claimant's acquittal by the court. In fact, DW admitted under cross-examination that the administrative proceeding was in respect of the same offense which claimant had been acquitted by the court. Nene Defense Counsel had argued in paragraph 3.5 of his reply on point of law that from the record of the court, there was nowhere DW made such admissions. The law is settled that the records of court and its content are binding on the parties, counsel, and on the court. Therefore, neither parties or their counsel nor the court can read into the record what is not there, and they cannot also read out of the record what is there. They must read the record in the exact content and interpret it in the same way. See these cases, H plus B, Synergy Limited and another, and Isoko Community Bank Limited citation captured, Oguta and Adelaja citation provided. No other record is expected to take preeminence over court record as to the veracity of what transpired in the proceedings of the court, especially when it became a contentious issue. See the case of Access Bank PLC and Shijuade citation provided. This court record, which is what clearly guides it, shows that DW made such admissions as captured above while under cross-examination by claimant counsel. Exhibit S5, which is the letter on administrative procedure, provides thus, and I quote, I refer to your letter of suspension of 14th May 2008 and the subsequent recall on the 2nd of September 2013. I've been directed to inform you that management is working on concluding the administrative proceedings initiated towards you in 2008. You will recall that official procedures were interrupted to allow Nigerian police conclude their investigations after your arrest. Paragraph 3, you are therefore not allowed to resume your official duties in the department until the above is concluded. Management will always contact you whenever your presence is required. Thank you, unquote. I think subjecting claimant to continue administrative proceedings after his recall to work for the same misconduct which a court of competent jurisdiction has acquitted him for is double jeopardy. This is against the general principle of penal laws in this country, including the 1999 Constitution as amended by its section 36, subsection 10. See the case of Nigeria Army and Aminu Kano citation captured. Once the court has cleared claimant and the defendant on the strength of his discharge and acquittal by the court and recalled him to work, the defendant had no right to subject claimant to another administrative proceeding for the same act again. In fact, Rule 030411B of the PSR provides, and I quote, "An officer acquitted of a criminal offense shall not be penalized for any charge of which he or she has been acquitted, but nothing in this rule shall prevent his or her being dismissed or otherwise punished on any other charges arising out of his or her conduct in the matter, provided that such charges do not raise substantially the same issue as those of which he or she has been acquitted. If the commission thinks fit, the usual procedure may be followed for the purpose," unquote, putting claimant's work on hold again after his recall until the conclusion of administrative proceeding in respect of the same offense, which he was acquitted, is in breach of Rule 030411B of the PSR. The defendant, after the acquittal of claimant and his recall, cannot decide to continue with the administrative proceeding on the same offense or misconduct in respect of which claimant has been acquitted. His discharge and acquittal is a bar to further proceedings on the same issue as provided for by the PSR. The defendant is stopped by law, no matter how strongly it feels about the said act, which is the subject of acquittal, from continuing with an administrative proceeding. The defendant who has acted illegally by subjecting claimant to an administrative proceeding wherein he was asked to stop work again until conclusion of the administrative proceeding after his recall to work in respect of the same offense, which was even more than 2 years after the commencement of same, which the court had pronounced upon, has acted contrary to the provision of the Constitution and Rule 030411 without legal justification, and as such cannot be protected by the provision of Section 2A of POPA. I so find and hold. I'm not unaware of the decision of the Apex Court Peaba GSC in the case of Idachaba and University of Agric Makurdi, citation captured, which learned counsel for the defendant is relying on as part of his additional authorities forwarded to the court, where the Apex Court stated that the period of limitation in Section 3 of POPA applied to the case, which was founded on employment or contract of service. That decision broke away from the earlier decision of the Apex Court that Section 3 of POPA does not apply in cases founded on contract, which includes contract of service, and for a while became the state of the law as to the application of Section 2 of POPA to cases founded on contract, including contract of employment. I also take judicial notice of the case of Tertiary Education Trust Fund, TED Fund, and another versus Aminu Abdurrahman Anas. Is an unreported appeal number CA/ABJ/CV/89/2022, which was equally forwarded to this court by learned defense counsel in support of his position that the period of limitation in Section 3 of POPA applies in cases of contract of service, and in which case the Court of Appeal also relied on the case of Idachaba Supra. The point needs to be made that at this stage, that the Apex Court in a more recent case reiterated the position that POPA does not apply to cases founded on contract in the case of Obasanjo and Wuroboga Nigeria Limited, citation captured, where Jaro GSC at pages 269 to 270, paragraph H in his lead judgment, quoted with approval the position of ECO GSC retired in the case of CIL Risk and Asset Management Limited, and Ekiti State Government citation also provided that, I quote, "The second limb of the appellant's submission on scope of Section 3 of POPA is that the provision does not apply to cases founded on contract or breach of contract." The appellant is correct. Numerous judicial dicta of this court support this submission. Osun State Government and Dalami Nigeria Limited, unquote. Interestingly, Abba Aji GSC, who delivered the lead judgment in the case of Idachaba and University of Agric Makurdi Supra, was part of a panel who decided the above case of Obasanjo and Wuroboga Supra, wherein learned jurists The learned jurist emphatically asserted at page 272, thus, and I quote her, does Section 2 of the Public Officers Protection Act apply to every genre and action of a public officer? Does it apply in the present suit to make it statute bad? The Public Officer Protection Act was not intended by the legislature to apply to contracts. The law does not apply in the case of recovery of land, breaches of contract, or for claims for work or labor done, unquote. Garba GSC, on his own part, while concurring with the lead judgment of Jaro GSC held at page 273, does, and I quote, the law is now beyond argument, since it has been firmly settled in many decisions of this court, that the provision of Section 2 of Public Officers Protection Act (POPA) do not apply for the purpose of limitation of actions to actions predicated on contracts or for recovery of land, unquote. In fact, Garba GSC, in support of his above position that Section 3 of POPA does not apply to cases founded on contract, relied on the case of CBN and Adedeji. Citation captured, a case founded on contract of employment or contract of service, just as in this instance, wherein the court in that case held that Section 2 of POPA would not avail the appellant in that case, because the case was founded on contract of service, which according to the court falls within the exception. The above reliance of Garba GSC on the case founded on contract of employment to support his assertion that POPA does not apply to cases founded on contracts and indication that contract of service is one of such contracts. In fact, the Supreme Court earlier have stated that contract of service is one of such contracts to which Section 3 of POPA will not apply. See the case of National Revenue Mobilization and Fiscal Commission versus Ajibola Johnson and others, citation captured. By the combined effect of the case of Obasanjo versus Uruboga Nigeria Limited Supra, the case of Revenue Mobilization and Fiscal Commission and two others, and Ajibola Johnson Supra, claimant's case being one founded on contract and specifically contract of service, and a claim for work and labor done, is exempted from the impression of a period of limitation in Section 3 of POPA. In my considered view, the claimant's claim in many respects constitutes an exception to the period of limitation in Section 2A of Public Officers Protection Act as espoused supra. The defendant also sought as an alternative in his notice of primary objection a decline of jurisdiction on the ground that it does not disclose reasonable cause of action against the defendant, as claimant has waived his right to request for the payment of arrears of salaries which accrue during the period of suspension. The position of the law is clear that the court can only consider an alternative relief or prayer where the main one fails. See these cases: Cavendish Petroleum Nigeria Limited and others were Deribi and another citation captured. EFCC and versus Akingbola citation captured. The case of MV, Caroline Mesk and others versus Noco Investment Limited citation also provided. Since the main prayer on statute of limitation of POPA addressed above has failed, the court is empowered to consider the alternative of non-disclosure of cause of action. And that's what I'm going to do here on that. A cause of action is the entire set of facts or circumstances giving rise to an enforceable claim, which also includes all those things necessary to give a right of action and every fact which is material to be proved to entitle a claimant to succeed in his action. This has nothing to do with whether or not the claimant will succeed in the final analysis of his claims. See these cases: Governor of Oyo State and others versus Ajunwa and others citation captured. Babas and Company Nigeria Limited and another and Okafo Udeji citation captured. Uwazoroye and Governor of Imo State and others citation provided. The notarial case of Idigbe and Adefarasin citation equally provided. In order to decide whether a suit discloses the cause of action, the court must restrict itself to the facts in the statement of claim without recourse to the other facts in the defendant's pleading. See the case of Ojiego and others as Hazan and others citation captured. Atoda and Access Bank and another citation provided. And the case of Owuru and another, and Adigu and another citation also provided. In determining whether the case of the claimant in this case discloses the cause of action or not, the court will restrict itself to the originating process and statement of facts filed by the claimant. Then the defense counsel had submitted in respect of a notice of preliminary objection that claimant, having waived his right to his salary during the period of suspension, viz. Exhibit A, attached to the affidavit in support of a notice of preliminary objection, he no longer has a cause of action against the defendant. Claimant by relief 5 in the complaint sought an order of this court setting aside the said letter wherein he forfeited his salary arrears because it was made under duress. Also, by his statement of fact, he gave facts which discloses the source of his grievance against the defendant. Specifically by paragraph 10 of his statement of facts, he averred that the said undertaking in the letter, which the defendant is relying on in this case to say he does not have cause of action, was made under duress, since it is only the originating process and the statement of fact of the claimant that should be considered in determining whether there was a cause of action. Relief 5 and paragraph 10 alone in the statement of facts have shown that claimant has a reasonable cause of action against the defendant. This is because in determining this disclosure of cause of action, the chances of success of the action or the statement of defense of a defendant should not even be a consideration. It is in the light of the above that I find that claimant's suit on the basis of a general form of complaint and the statement of facts have disclosed sufficient cause of action against the defendant. Therefore, issue 1 is resolved in favor of the claimant. Now to issue 2. Let me first address the objection of learned defense counsel to the admissibility of Exhibit S3, S6, and S7 on the ground that they are uncertified public documents. Let me start with Exhibit S3. Exhibit S3 is made up of an original copy of the letter written by the defendant, a public body, to the claimant counsel, who had custody of same till the point of tendering it in court, in response to the said letter written by the defendant. It is my view that the original correspondence between the defendant and the claimant counsel, that is the first document in Exhibit S3, need no certification to be admissible, even though it was written by the defendant, a public body. I'll proceed to explain why I took this view. It is now patent that an original of a public document needs no certification to be admissible. Section 86, subsection 1 of the Evidence Act 2011 provides thus, and I quote, primary evidence means the document itself produced for the inspection of the court, unquote. The apex court in the case of PDP and INEC citation captured, while considering a similar issue as the one herein pertaining to the argument whether the original of a letter written to the 25th respondent by the Independent National Electoral Commission was properly tendered without the necessity of subjecting it to certification, pronounced on whether primary evidence, which is a public document, requires certification under Section 104 of the Evidence Act. The court per Okoro GSC held as follows, and I quote, the nearest senior counsel for the 1st to the 24th respondent, however, submitted that the letter written by Independent National Electoral Commission to the 25th respondent was properly tendered by him without the necessity of subjecting it to certification since it was in his custody. He cited and relied on the case of Itogu and LPDC, citation was provided therein. There is no doubt that Exhibit W05 was written by Independent National Electoral Commission and addressed to the 25th respondent who had custody of it up to the point of tendering same. Was this document of a character that ought to have been certified before tendering? Section 102 of the Evidence Act 2011 makes the following documents public documents. It says by Section 103 of the Act, all documents other than public documents are classified as private documents. Exhibit W05, the subject of this issue, was the original correspondence between 25th respondent and Independent National Electoral Commission. The said letter was in the custody of the 25th respondent and remained so up to the point it was tendered. It is my view that there was no need to certify the original copy of the letter, even though it was issued to him by a public officer. It is the public officer who keeps the original of a public document who certifies a copy of it, which can be tendered where the original cannot be tendered. Put differently, the only categories of public documents that are admissible are either the original document itself, or in the absence of such original, certified copies and no other, unquote. See also the case of Owaka versus RSH PDA, citation captured. The case of MBM PLC and another versus Adeosun Business Investment Limited and other, citation provided. The case of Anagbadu and Farouk, citation captured. And the case of Habib and the state, citation equally provided. Learned Defense Counsel clearly misconstrued the import of the provisions of the Evidence Act. The second letter, which makes up Exhibit S3, is a copy of the letter written in response to the letter of the defendant above. This document falls within the definition of primary evidence in Section 86(2) of the Evidence Act. Section 86, subsection 2 of the Evidence Act provides, and I quote, "Where a document has been executed in several parts, each part shall be primarily evidence of the document," unquote. There is no gainsaying that the said document dated 24th of December 2021 executed in several parts, having been made from the original, which carries the seal by one mechanical process and was equally signed by claimant counsel like the original with a blue biro, as seen on the document, and used as the acknowledgement copy of the original received by the defendant, and on which the office of the chief medical director of the defendant put its stamp and signed. This document is primary evidence of the original served on the defendant because it was executed in several parts. Thus, it is a primary evidence on its own and requires no certification to be admissible. Thus, I find that both documents that make up Exhibit S3 are admissible without the need for certification because they are themselves primary evidence. Now to Exhibit S6, which is made up of a bundle of documents. The first one is a copy of the letter of reminder written by claimant and received by the defendant on the 27th of October 2011, as seen on the original acknowledgement stamp, which receipt qualifies the document as a public document, which is now in possession of the defendant. The said first letter falls within the category of documents referred to in Section 86, subsection 2 of the Evidence Act. The signature on it, even though in black, clearly shows that it was executed by claimant and not a photocopy of a signed one. The claimant clearly signed that copy himself, looking at the signature on it, which is not a photocopy. Apparently, the said first letter, which is part of a bundle of document called Exhibit S6, was made in several copies such that they are executed in parts by claimant, who served one on the defendant and kept another copy made through the same mechanical process with the original, which was used as the acknowledgement copy in his possession, and which was what he tendered in the circumstance of this case. The said letter titled Letter of Reminder, being a primary evidence itself under Section 86(2) of the Evidence Act, does not need certification to be admissible in evidence, I so find and hold. The second letter that makes up Exhibit S6 is a photocopy of the original of the document dated 15 August 2011, written by claimant to the defendant, and which was used as acknowledgement copy of the original received by the defendant as seen on the acknowledgement stamp. The stamp of the defendant and the signature and date of the officer who received it is clearly on the document, which evinces that the defendant received the document and it is in his custody and qualifies as a public document, and as such, the only copy admissible of same is either the original copy or a certified true copy of same. See the case of Iraku and the state, citation captured. The case of Emeka and Chuba Ikpeazu, citation provided. Failure of the claimant to tender either the original one or a certified true copy of the letter is fatal to the admissibility of this document. The position of the law is now clear that when an inadmissible document is inadvertently admitted by the court, same must not be acted upon and ought to be expunged at the stage of writing judgment. See the case of OJ and FRN, citation captured, Duro Sharo and Ayorinde, citation provided, Fashin and Ogunkayode, citation equally captured. Accordingly, the said letter, which is part of a bundle of documents marked as Exhibit S6, is hereby expunged from the record of this court. I so hold. The last of the bundle of documents marked Exhibit S6 is an original of a letter written by the defendant to claimant dated 31st October 2011. As reasoned herein before, an original copy of a public document is itself admissible as primary evidence without the need for certification. See the case of Owoka and RSH PDA Supra, the case of FBN PLC and another and Adeosun Business Investment Supra, the case of PDP and INEX Supra. The said document being an original of a public document is thus admissible without the need for certification, I so find and hold. Exhibit S7, which was equally objected to by learned defense counsel, is a photocopy of claimant's payslip generated by IPPIS. First, let me address the objection of learned counsel as regards the relevance of the said Exhibit S7. Learned counsel had submitted that the piece of evidence is not relevant to the issue at hand. It is the law that what determines the admissibility of evidence is relevancy. In fact, an issue is admissible if it is relevant to the matter before the court. See the case of Andoka and Obot and another citation captured, Start Oil Nigeria Limited and Indicon Nigeria Limited and another citation captured. The case of Nwabuka and others and Nwadi and other citation also provided. Basically, admissibility of evidence and documents in particular are governed by three elements or conditionalities, which are: one, there must be pleaded facts in the pleadings in respect of the documents sought to be admitted in evidence. Two, it must be relevant to the issue in controversy or dispute between the parties before the court. And three, it must be admissible, regard her to other basic requirements on admissibility of evidence in general. See the case of Garba and others and Director General, Bureau of Lands, Kwara State and another citation captured. The case of Olayemi and Ashaolu, citation equally captured. Claimant in this case is claiming for his salaries of the period he was on suspension. Specifically by paragraph 14 of his statement of fact, he averred that his monthly take-home during that period of suspension is 89,528 naira 64 kobo, and pleaded and relied on his payslip in support of this fact. However, a perusal of Exhibit S7 shows that it is a payslip of claimant for February 2017. The fact in dispute is in relation to claimant's salary between 2008 to September 2013. I am of the view that the said payslip is not relevant to the fact in issue, which is as regards claimant's salary at the relevant period in 2008 and 2013. Exhibit S7 is not relevant in my view. This would then lead me to address the other objection raised to the admissibility of the said exhibit by learned defense counsel. According to learned defense counsel, the document is not admissible, being an uncertified photocopy of public document. Section 102 of the Evidence Act defines public document as document forming the official acts or record of the official acts of A, the sovereign authority, B, official bodies and tribunals, C, of public officers, legislative, judicial, and executive, whether of Nigeria or elsewhere, and public records kept in Nigeria, of private documents. See also the case of NAFDAC and Reagan Remedies citation captured. Exhibit S7, no doubt, qualifies as public document, and which the only secondary copy admissible is a certified true copy. See the case of Hangba and Nigeria Army and another citation provided. The case of Aromalara and Agoro, citation provided. I agree with learned defense counsel that it is also a computer-generated evidence. I will proceed to explain why. On the authority of the Supreme Court decision in the case of Attorney General of the Federation, Anue Bunwa, is a 2022 decision of the Supreme Court. A statement of account is a computer-generated evidence in line with Section 84 of the Evidence Act, because it is the algorithm stored in the database of the bank that produces the statement. The Apex Court in the above case also emphatically held that the mere fact that a document is typed using a document does not make it a computer-generated evidence. But what makes a document computer-generated is the information stored on the computer, because according to the court, Section 84 of the Evidence Act intends that only complex evidence generated from the computer against which the calculating or measuring accuracy of the computer is dependent upon or stands to be tested is to be subjected to scrutiny by the court, and not ordinary documents printed out of a computer. The payslip in this case is no different from the status of a statement of account, because it's the algorithm stored in the database of the IPPIS that produces the payslip. The payslip therefore qualifies as a computer-generated evidence, not because it was printed or typed from a computer, but because of the information contained in it, which is gotten from the database of the IPPIS. Just a moment, please. The payslip ought to be accompanied by a certificate of compliance in line with Section 84 of the Evidence Act, in order to ensure that no one illegally or without authorization tampered with the source, which is the data as officially imputed in the database of the IPPIS. And such certificates should include that the computer was in good condition when the payslip was generated. The photocopy of the payslip not being a certified true copy, and one not accompanied by certificate of compliance being computer-generated evidence, is thus not admissible, and same is at this stage expunged from the record of this court. Now, claimant by his reliefs 1 and 2 sought declaration that being a civil servant is entitled to have salary while on suspension, and the other half after he was discharged and acquitted. As reasoned earlier in this judgment, claimant was suspended based on a criminal allegation, and parties in this case, by their respective final written addresses, have relied on the provision of Rule 030406 of the PSR, which I have considered earlier in this judgment. The provision of the said rules no doubt impose a term on suspension under the rules, as reasoned supra. Since parties agree that the rules bind both parties, then it means that claimant is bound by the provision of Rule 030406, which says that suspension includes suspension from the enjoyment of emolument. In fact, I'm in complete agreement with the position of Learned Defense Counsel in paragraph 2.2 to 2.3 of his reply on point of law to the claimant's final written address, that it is interdiction that attracts half pay and not suspension. And the rules clearly provides that suspension is not synonymous with interdiction. It is clear from the provision of Rule 030404 that interdiction is the one that attracts half pay, while on interdiction and not suspension. Claimant obviously misconstrued suspension under the rules with interdiction for him to be contending that he was entitled to half pay while on suspension, and the other half after he has been discharged and acquitted by the court. Suspension under the rules also includes suspension of payment, salaries during the relevant period. As such, this court is not inclined towards granting reliefs 1 and 2 in the general form of complaint. Now let me address relief 3 in the originating process. Suspension is not synonymous with termination. See the case of Elizabeth and Ondo State Judicial Service Commission and an order. The case of Galadima and Governor of Yobe State and others, citation captured. As reasoned supra, admittedly, the PSR by Rule 030406 imposes a term on suspension that an employee suspended will also have his emolument suspended. The key word here is that the emolument of such employee will be suspended and not permanently denied. There's a need for the court to clarify this. I've reasoned severally in this judgment that upon the discharge and acquittal of claimant is entitled to be paid his salaries during the period he was suspended, because same was kept in trust for him. And since he was vindicated by the court, the import is that he did not do anything to warrant the suspension in the first place, and so ought to be paid these salaries that were temporarily suspended. See the case of Lowonihi and EFCC Supra, the case of City Central Group of Companies Limited and Eze Supra. Learned Defense Counsel had submitted in his final written address that assuming claimant was even entitled to be paid, his letter of commitment in Exhibit A2 amounts to a waiver, and that since the right to those salaries is for his sole benefit, he can waive same. The effect of the above is that the defendant sought to rely on the equitable reference of waiver. On the equitable defense of waiver. He posited that since claimant has waived same, he's not entitled to be paid. Earlier in this judgment dealt extensively with the fact that claimant was not cross-examined by defense counsel on the material point of the voluntariness or otherwise of the said Exhibit H2. I accordingly held that this is a tacit acceptance by the defendant that the said Exhibit A2 was not made voluntarily. The question that agitates the mind of this court at this stage is if, in the light of the above findings, Exhibit A2, which the defendant has tacitly accepted to be involuntarily made, can be said to constitute a waiver. The apex court in the case of Eze and Okechukwu and other citation captured explained waiver does, and I quote, "It is said that waiver is the intentional or voluntary relinquishment of a known right, or such conduct as warrants an inference of the relinquishment of such right. It is also arises when one dispenses with the performance of something is entitled to, whether conferred by law or by contract, with full knowledge of the material facts, or when a person does or forbears to do something, the doing of which is inconsistent with the right or his intention, to rely or insist upon it. It includes the disinclination to take advantage of some defect, irregularity, or wrong in the act or action of another through acquiescence, renunciation, repudiation, abandonment, or surrender of the right to so," unquote. See also the cases of Benue State University and Mogaji citation captured, the case of Mamonu and another, and Dikat and other citation captured, the case of Olefiagba and others, and Abdurrahim and other citation captured, the case of Auto Import Export versus Adebayo and other citation captured. Since the purported waiver is not voluntary, same cannot be given judicial approval by this court. It is in the light of this that it countenances the submission of learned defense counsel on the purported waiver. Claimant's emolument, which were suspended pursuant to Rule 030406 of the PSR, which were kept in trust for him and ought to be paid upon his acquittal and subsequent recall back to work, as I've stated severally, taking cognizance of the decision of the apex court on same. Coercing claimant to waive the salaries for the period of the suspension as a condition for his recall, vide Exhibit H2, is illegal, as reasoned severally in this judgment, and the court cannot close its eyes to such an illegality. Assuming there was even any ambiguity regarding the payment of the said arrears to claimant, the most favorable to claimant will be adopted, and which is that it cannot be denied on the basis of an involuntary commitment or purported waiver. This position of the law was aptly captured by Ogunwumiju JSC while delivering the lead judgment in the case of NNDC versus Ugbagbe, citation captured, wherein his lordship emphatically held inter alia does, and I quote, "However, it is a principle of labor law that any ambiguity regarding the payment of any entitlement to an employee must be resolved in favor of the employee, in this case, the retiree. I cite with approval Chiroma and Fort Oil PLC suit number NICS/ABJ/165/2018, delivered on 2nd of May 2019 by Justice B.B. Kanyip, PhD. The case of Owulade and Nigeria Agip NICN/LA/41/2012, delivered on the 12th of July 2016 by Honorable Justice B.B. Kanyip, PhD, unquote. Abubakar JSC, while concurring with the above position, on his own part in the same case, at page 40, held inter alia does, and I quote, "I am of the view that where there is seeming ambiguity in the payment of entitlements of an employee, such ambiguity must be resolved in favor of the employee, and this being the case," unquote. It is in the light of the above that I find that claimant, having not been paid any salary during the period he was on suspension, is entitled to his full salary since he has been discharged and acquitted of the offense or the act leading to his suspension. Claimant was suspended from May 2008 and recalled in September 2013. According to claimant, while under cross-examination by learned defense counsel, he was only paid his cumulative salary from September 2013 to December 2013, the effect of which is that claimant was paid as from September 2013. Claimant, in view of the above finding, is thus entitled to be paid from May 2008 to August 2013. Accordingly, Relief 3 succeeds. In respect of Relief 4, learned defense counsel had under Issue 3 in his final written address argued that claimant admitted while under cross-examination against his interest in this case that there was no administrative proceedings conducted against him after his discharge and acquittal, which admission is fatal and puts an end to all claimant's claim as regards the administrative proceeding in the case. I've gone through claimant's evidence under cross-examination, and it shows that when claimant was asked if he was tried administratively, he answered that the administrative panel was before Exhibit S. The position of the law is clear that for an admission against interest to be relied on and accepted by the court as proof of the matter or a fact in issue, it must be weighed along with the entire evidence on record in order to determine its correctness and proper probative value. An admission based on a mistaken belief of the facts and true position of the law is not an admission against interest. It is against all sense of justice to rely on admission against interest when the truth of the admission is not borne out by other material pieces of evidence on record of this court and/or does not reflect the position of the law. See the cases of Idigbe and others in Ashadariyu citation captured, Orakwe and Orakwe and others citation provided, Oyetuji and Awoyemi and others citation captured, Udutola and another and Paper Sack Nigeria Limited citation also provided. It is clear that the so-called admission in the evidence of claimant under cross-examination did not reflect the true legal position of the matter in respect of whether there was an administrative proceeding after he was discharged and acquitted on the same allegation. It did not vindicate or reflect the material evidence before the court. As reasoned earlier in this judgment, while addressing issue 1, Exhibit S5 clearly shows that after claimant's recall on administrative proceeding, which was in place before his suspension was resumed, DW also admitted this fact under cross-examination as reasoned earlier in this judgment, which he stated that part of the purpose of the letter given to claimant after his recall, which is Exhibit S5, is to conclude the administrative proceedings against claimant. Also, by paragraph 12 of the statement of defense of the defendant, it is clear that the defendant continued the administrative proceeding despite claimant's discharge and acquittal because it averred therein that the proceeding had commenced before claimant was charged to court, and that despite his discharge and acquittal by the court, the defendant is duty-bound to make a finding on the said complaint against the claimant. The so-called admission is at variance with the evidence on record and the pleadings of parties, and as such, does not reflect the true position of things, thus is without any probative value and cannot be resolved in favor of the defendant. I have taken note of the submission of learned claimant counsel by paragraph 4.1 of his final written address while relying on the case of Garba and University of Maiduguri Supra, that the allegation against claimant being criminal in nature could have only been tried by a court of competent jurisdiction and not any administrative panel, even in the first instance. The above position of counsel was equally expressed by the Supreme Court in the case of CBN and Dine, citation captured, and also in the case of Onwusuku and Civil Service Commission, citation provided, as well as in the case of Nasarawa State University and another versus Nekere, citation captured. The court in the case of CBN and Dine Supra held that where there is an allegation of criminal wrongs against a person, including an employee, the jurisdiction to determine the allegation invested in the court and the exercise of such jurisdiction cannot be usurped by any administrative tribunal. The court went further that the reason is simple. Where there are serious allegations of crime like fraud and forgery, The matter is beyond the power of an administrative panel that the allegation of fraud against the respondent, in that case, the employee of the appellant, ought to be pronounced upon by the courts of law, as the allegations are of serious requiring proper judicial process in all their ramifications, and that the respondent herein should have been tried by the ordinary court before the dismissal by the employer. However, the same apex court that delivered the case of CBN and Dine Supra has modified the above position when in its decision on 27th of May, 2022, reported as Federal Republic of Nigeria and Ngajiwa citation captured, wherein the court Pelgumiju GSC expatiated on the extent of the powers of an employer to exercise its powers over allegations against employees which are equally criminal in nature, that where the employee commits an offense which imparts on his character and his ability to sustain the trust of his employer and his ability to continue to do his job efficiently and effectively, like fraud, stealing, bribery, and corruption, and so on, then the employer is at liberty to disengage the employee before conclusion of criminal proceedings. However, if the criminal offense is one that does not impart on the character or ability of the employee to do his job, then the employer has to wait for the conclusion of criminal proceedings before the disciplinary proceedings can start. And these are offenses like assault, murder, traffic offense, and so on, and in respect of which the employer has to await the outcome of criminal prosecution before any disciplinary proceedings can be initiated and concluded by the employer. Agim JSC on his own part stated at pages 485 to 486, paragraph D to E, that, I quote, Leonard SAM for the appellant argued that because of the criminal character of the act, the NJC cannot deal with the aspect of that act that constitute judicial misconduct until a court had tried the aspect of the act that constitute a crime. This notion is no longer tenable. In view of our decision in Yusuf versus Union Bank Limited, citation was provided there. In case of Danton and Civil Service Commission, Plateau State, case of Arinze and FVN Limited, and other cases that the prosecution of an employee in a court is not a sine qua non to the exercise of disciplinary power by an employer for an act of misconduct that is also a crime. In any case, assuming the notion conveyed in our decisions in the Lawyer, Medical, and Dental Practitioner Disciplinary Committee Supra, O.G. Shokefun and Akinyemi Supra, Garba and University of Maiduguri Supra, the criminal prosecution of an employee in a court for an act of misconduct of an employee that is also a crime must precede the exercise of the employer's disciplinary power still applies as an inflexible. Those decisions cannot apply to cases such as this because none of them involve a serving judicial officer, unquote. It is clear from the above position of the letter juries of the Apex Court, which was part of a majority decision on the above case, that the position in Garba University of Maiduguri Supra, which Learned Counsel relied on, and which position is similar to the position of the court in CBN and Dine Supra, is not inflexible. It has obviously changed with the tides of time. It is thus clear that an employer has a right to deal with the misconduct of an employee, even where it is criminal in nature, and it's one that imparts on the character of the employee or his ability to sustain the trust of his employer. I so find and hold. In the instant case, the allegation against claimant was that of a criminal conspiracy and fraudulent fraudulent execution of deed, which carries a stigma on his character and which the employer has power to discipline him for even before he's charged to court. However, the defendant chose to suspend its administrative proceeding, which was initially instituted against the claimant, and claimant was charged before a court of competent jurisdiction. To my mind, the moment the defendant exercised such a right, and the court of competent jurisdiction became seized of the matter and even determined the case on the merit, viewed as it is by discharging and acquitting the claimant, it is a disrespect to the judicial system for the defendant to recall claimant based on the conclusion of trial, now subsequently stop him from work again on the guise that he was continuing with the administrative proceeding it had initiated against claimant before he was charged to court. The said administrative proceedings ought to terminate once claimant had been discharged and acquitted and recalled back to work, as I've stated severally in this judgment. As reasoned earlier in this judgment, continuing to subject claimant to the administrative proceeding on the same offense even after he was discharged and acquitted and recalled back to work is tantamount to double jeopardy, which our Constitution frowns at. It is an affront to the power of the court for the defendant to continue trying claimant under the guise of continuing any administrative proceedings after he has been discharged and acquitted and has been recalled to work. It is only logical that relief 4 in the general form of complaint will succeed and thus succeeds. Now to relief 5, which is as regards Exhibit H2, which according to claimant was made under duress. I've earlier addressed the issue of the letter extensively. I've also found that the defendant had tacitly accepted the testimony of claimant that the said letter was made under duress when learned counsel on its behalf failed to cross-examine claimant on this material point. See the case of Gaji and Kwaye Supra. It is thus in my view that it is thus in view of this that I find that Exhibit A2, which was made under duress, cannot be allowed to stand by the court. It is in the light of the above that I set same aside. Relief 5 also succeeds. In respect of relief 6, claimant claims salary arrears in the sum of 5,640,304 naira 32 kobo. This is no doubt in the realm of special damages. He pleaded facts in support of this in his statement of fact. He equally relied on the pay slip, which the court has earlier in this judgment rejected for reasons earlier given. In fact, learned claimant counsel in issue 3 of his final written address admitted that the salary pleaded and the evidence in support of which is the pay slip is in conflict with the last salary claimant was paid in April 2008 before his suspension, which error he sought to correct to no avail in this court. In this case, he sought via the motion he filed on 25th of October 2022 to reopen his case and clarify the issue of his last salary, which according to the motion was not the amount stated in the statement of fact, but that the sum of 66,340 naira 16 kobo, which according to claimant was the last salary received in April, as against the sum of 89,528 naira 64 kobo pleaded in the statement of fact. The said application was refused by the court for the reasons given in its ruling of the 1st of June 2023. Be that as it may, special damages are only awarded upon strict proof. See the case of NA and Ozo, citation captured, Air Liquid Nigeria PLC and NAM, citation captured, the case of SPDC Nigeria Limited and Table, the 7th, citation captured. There is no evidence in support of a particular sum claimed under these special damages for the arrears of salaries during the period of suspension. Thus, same must fail. Consequently, relief 6 fails. Notwithstanding the above, the point needs to be made here that this court has previously made a declaration in relief 3 that claimant is entitled to his full salaries arrears for the period of suspension after he was discharged and acquitted by the court. His relief for the particular sum claimed as the total sum of the said arrears of salary has failed for the reasons given in the previous relief. However, from the submission of learned counsel on behalf of the claimant in his final written address, the amount stated in relief 6 and the evidence put forward in support of same, which the court has rejected earlier, were errors which he sought to correct, but though failed. A court of law exists to do justice, and this is justice in a substantial sense and not in its technical sense. Claimant has gotten a declaration that he is entitled to be paid those salaries that accrued to him during the period of his suspension, but has failed in his relief 6 to prove the particular sum claimed. In appropriate cases, a court is empowered to make consequential order, basically to meet the justice of the case before it. See these cases: Ikowu and Amcon, citation captured; Obaniko Ren and other, and Yishawu and other, citation captured; Lyinka and Others versus Gegele citation provided. The justice of this case, even though claimant failed to prove the particular sum claim, demand that the court should give a consequential order to the defendant to entitle to effectuate relief 3, that the claimant's salary during the period of suspension should be computed by the defendant and paid to him. It is in the light of this that this court, despite failure of relief 6, will order in its consequential power that claimant's salaries during the period of his suspension be computed and paid to him forthwith. I so find and hold. As per relief 7 on general damages, ordinarily general damages may be given where a wrong is established. Claimant in this case has been able to prove that he was wronged by the defendant by the non-payment of salaries which accrued during the period of suspension upon his discharge and acquittal by court. However, the court has found that he is entitled to be paid his salaries for the said period. Awarding the claimant general damages when the court has ordered that his salaries be paid to him will, in my view, be double compensation, which court has been warned to refrain from. See the case of Glow and another and Jami citation captured, Yakubu and Adamawa state government and other citation captured. This is, although Section 19D of the National Industrial Code 2006 empowers this court to award compensatory damages in deserving cases, this is not one of such deserving cases, as doing so would amount to a double compensation. Therefore, relief 7 fails. Claimant by relief 8 is claiming for exemplary damages. Exemplary damages, otherwise known as punitive damages, are awarded so as to punish and thereby deter the reckless conduct of a defendant. See the case of Lokoja and Edenagu and Others and Samson, citation captured. Such exemplary damages may be granted by the trial court under certain conditions. A, when any action of servants of government is oppressive, arbitrary, or unconstitutional. B, when the defendant's conduct has been calculated by him to make a profit for himself. Or C, when the exemplary damages is expressly authorized by statute. See the case of Basi and AG Akwa Ibom State and Others, citation captured. Udiba and Muemu, citation also provided. The defendant in this instance has acted wrongly by not paying claimant salaries after he was discharged and acquitted by a court of competent jurisdiction and his subsequent recall. The act of a defendant is ordinarily reprehensible and one deserving of high exemplary damages. However, I noticed that the defendant in its pleadings and statement on oath sought to make the subsequent dismissal of claimant in 2016 an issue, and that because of that, the claimant's action has no basis. The relief sought by claimant and his pleadings clearly show claimant's grounds in this case is not as regards anything that happened in 2016 or his eventual dismissal from service. His grounds in this case was as regards his previous suspension on a separate allegation and the salaries that accrued during that period. Therefore, the claimant's dismissal or letter of dismissal, which was tendered by the defendant in this case, has nothing to do with the fact of his suspension, which is an issue in this case. In fact, DW admitted this much under cross-examination on 29th of June 2022, when he answered in the affirmative when asked that the letter of dismissal is not connected to his case, to this case. From the pleadings of the defendant, it is clear that the defendant wants to use averments and the evidence of claimant's dismissal, which is unrelated to the facts in issue on salaries in this case, to prove the character of claimant. Section 78 of the Evidence Act provides that, I quote, in civil cases, evidence of the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is inadmissible, except insofar as such character appears from facts otherwise relevant, unquote. It is clear from this that evidence of character is only admissible where it appears from facts that are relevant. The fact that claimants were eventually dismissed from another misconduct after his suspension which suspension is fulcrum in this case, makes its dismissal a relevant fact. I say so in view of the provisions of Section 6, subsection 1, which states that any fact is relevant which shows or constitutes motive or preparation for any fact in issue or relevant fact, the conduct, whether previous or subsequent to any proceeding, A, of any party to any proceeding or an agent to such party, in reference to such suit or proceedings, or in reference to any fact in issue in it, or a fact relevant to it, and B, of any person, an offense against whom is the subject of any proceeding is relevant in such proceedings, if such conduct influences or is influenced by any fact in issue or relevant fact, unquote. The said exhibit H3, which is the letter of dismissal and the fact of claimant's dismissal, will not be ignored by the court because it is a relevant fact which shows conduct of claimant previous to this proceeding, which conduct is similar to what he was suspended for. By the provisions of the evidence that evidence of a character may only be given in line with Section 79 of the Evidence Act, which provides thus, I quote, notwithstanding Section 78 in civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive may be given in evidence, unquote. Thus, the court may consider any evidence of character given in civil proceedings if it is such that may affect the amount of damages which a party ought to receive. If the court was even inclined towards awarding claimant separate damages under the head of general damages, for the fact that claimant again committed a similar offense to the one which he was initially suspended for and which saw to his dismissal, is such that could affect the amount of damages which he ought to receive. It is in the light of the above that I do not find the claimant worthy of an award of exemplary damages, and thus relief age fails. Parties are to bear their respective costs. Judgment is entered accordingly. So, learned counsel, copies of this judgment will be forwarded to you. That's the judgment of the court. So we have come to the end of today's proceeding. I cannot hear you, learned counsel. Unmute your system.
You unmute yourself.
Unmute yourself. Learned counsel, I cannot hear you. Look at your phone and unmute yourself.
Okay. Can you hear me, my lord?
Yes.
My lord, I'm most grateful for this Rudak's judgment. The industry you put in this judgment is alarming. And your analytical skill is superb. And the academic spices that characterize this judgment is another story to be told in another. We thank you for this wonderful judgment, and we pray that God will reward you with more work. We meet you at the top. May my Lord be pleased.
Thank you, learned counsel.
I would like to thank my Lord for the well-considered judgments. Thank you, my Lord.
Very well. So we'll come to the end of this proceeding. I will now exit the courtroom. Court will rise.